chair now recognizes Mr. Tolman for his 5 minutes.
Chairman Biggs, Ranking Member Nadler, Ranking Member Jackson-Lee, and distinguished members of the committee, thank you for inviting me to testify today. I am a former United States Attorney for the District of Utah, appointed by George Bush in 2006. Today, however, I serve as the Executive Director of Right on Crime, a national criminal justice campaign focusing on conservative, data-driven solutions to reduce crime, restore victims, reform offenders, and lower taxpayer costs. As U.S. Attorney, I remember a plaque in the halls of justice that read, "The hallmark of fairness in the administration of justice is consistency." And yet this principle can be easily lost when there are too many federal criminal laws to keep track of, let alone understand. James Madison warned of this issue in Federalist Paper 62, writing, "It will be of little avail to the people if the laws be so voluminous that they cannot be read, or so incoherent that they cannot be understood." Madison was on to something, because we have no idea how many crimes are on the books, as many have commented today. Nobody really knows the number of crimes. What we do know is that over-criminalization offends both sides of the aisle and is antithetical to our nation's founding principles. Criminal laws now cover so many facets of our everyday lives that the government can target citizens with impunity. Many of these crimes are easy to prosecute because many lack mens rea, the mens rea element. To commit a crime, you have to do it and you have to mean to do it, or at least know that it could happen. But often mental state requirements are abandoned, allowing the government to prove its case by a person's actions alone. This isn't how our criminal laws are meant to function. The bloated administrative state contributes greatly to over-criminalization. Faceless bureaucrats have made thousands of activities illegal, but they don't have to justify their decisions to the voter. Lastly, over-criminalization encroaches on state prosecution powers. When Congress oversteps into the traditionally state-held criminal prosecution space, state offenses can be unnecessarily replicated, making everything a crime and everyone a potential criminal. Over-criminalization is problematic in normal times, but we're living in unique time with political pressures taking precedent over the rule of law. I've worked in the criminal justice system for over 25 years and cannot believe how the current DOJ is choosing to throw away the rule of law to attack political enemies. When I was U.S. Attorney, I was determined to prosecute both Republicans or Democrats alike, so far as the facts and law supported the charges. But times have changed. Now federal prosecutors use their massive discretion and the overabundance of applicable laws to target whomever they choose. Even state prosecutors have jumped on the bandwagon, with the most relevant example being the targeted prosecution of President Trump by DA Alvin Bragg. This case didn't have enough evidence to support a legitimate federal charge, but prosecutors seeking to gain political points have chosen to target political enemy number one. Even for Democrats, this should be concerning, because if it's Donald Trump today, it could be you tomorrow. And prosecutions, even politically motivated ones, have the guise of legitimacy and are difficult to undercut or question. Partner this with our over-criminalization problem, and it's easy to see how power can be abused. Justice Scalia pinpointed this issue almost 30 years ago, warning that prosecutors, if left to their own devices, can pick people they think they should get rather than cases that need to be prosecuted. And with there being thousands of crimes to choose from, a prosecutor can target a man and then search the books to pin an offense on him. This should scare every member of this committee. My written testimony goes into more detail on how to avoid and solve this problem, but I'll quickly summarize some suggestions. First, Congress should practice restraint in creating more federal criminal laws. Decriminalization should be as equally important. But if Congress does pen a new criminal statute, it must ensure that it has a mens rea element. Also, this committee can revive broader mens rea reform by considering bills that attach a default mens rea to every statutory and regulatory offense. Next, Congress can conduct robust oversight. President Trump issued an executive order that told agencies to specify mens rea standards and make regulatory crimes understandable. President Biden undid this executive order. Why? This committee can get to the bottom of that and urge the administration to take over-criminalization seriously. In a similar vein, agencies' powers must be reined in. The fourth branch shouldn't be able to impose weighty criminal sanctions on Americans. This power belongs to the people's representatives. Over-criminalization threatens our public safety, individual liberties, and the fair administration of justice. Consistent application of the law is a cornerstone of our criminal justice system, and addressing our over-criminalization is a critical step to achieving this goal. I appreciate your time and look forward to any questions you may have.
Thank you, Mr. Tolman.